right, so this week you learned the common law contract rules, and today we're going to have a brief review, or contracts in a nutshell. All right, so let's get going. So elements of a legally enforceable contract. You learned that under the common law, the basic elements of a legally enforceable contract include offer, acceptance, and consideration. Of course, you must have competent parties and a lawful objective, and the contract must be in the proper form. So let's go ahead and get started with reviewing what you learned this week. So types of contracts. A contract will either be an express contract or an implied contract. An express contract is one that's entered into through language. It could be oral, it could be written. An implied contract, on the other hand, is implied or deduced from the conduct of the parties. The example we used in class was a visit to the doctor's office. A contract will either be an informal contract or a formal contract. The significance of a formal contract is that they are enforced not necessarily because you have offer, acceptance, consideration, but a formal contract is enforced because of the formality with which it was executed is sufficient to show that the parties truly intended to enter into a contract. A contract will either be a bilateral contract or a unilateral contract. A unilateral contract is one where the offer is accepted by performing an act. It could be a reward for a dog. So how are you going to accept this lost dog, $200 reward? Well, you're not going to call up the owner of the dog. You're going to first find the dog and then call the owner. A unilateral contract, again, is accepted by performing an act. Another case we talked about in class was a golf tournament, and the sponsors of the golf tournament offered a new car to anyone who made a hole-in-one on the 8th hole. A bilateral contract, on the other hand, is where you exchange a promise for another promise. A valid agreement. In order for there to be a valid agreement, there must be offer plus acceptance. An offer must be communicated from the offeror to the offeree. If you do not note that an offer exists, then there's nothing for you to accept. We also talked about offers made in jest. We talked about two cases, an old Virginia case where the offer was considered to be a serious offer. That was Lucy versus Zamer. And then the second case we talked about was Leonard versus PepsiCo, where Pepsi offered a new Harrier jet to anyone who redeemed Pepsi points. That was considered to be an offer made as a joke. And of course, I just wanted to mention that an invitation to negotiate is not a valid offer at all. So an ad in the newspaper, a sales circular, or catalog is not an offer. For practical reasons, first, there could be a misprint. And the second reason is that no seller is deemed to have an unlimited supply. Revocation of an offer. An offer can be revoked any time prior to it being accepted. The exception to the rule, of course, is an option contract, also known as an option offer. An option contract simply is a separate contract to keep the offer open for a specified period of time. Offers can be revoked because of lapse of time. So if I tell you you must accept by a certain date and you do not, then the offer is revoked. Incapacity of either the person making the offer or the person to whom the offer is made. Supervening illegality. If what I've offered to do later becomes illegal, that revokes my offer. Destruction of the subject matter of the offer, and of course, rejection. Rejections revoke offers. Counteroffers revoke offers as well. The mailbox rule only works with acceptances. And the mailbox rule says this, that an acceptance is effective the moment that it's properly mailed. The exception to the rule, of course, is this. If the offer states that acceptance is not effective until it's received, then the mailbox rule will not operate. All right, so we have offer plus acceptance. Acceptance must mirror the offer. If it does not, then it is considered to be a counteroffer, and counteroffers revoke offers. So, example, I offer to sell you my house for $50,000. You decline my offer and offer to buy my house for $45,000. You've just made a counteroffer. You cannot come back and then accept my original offer because your counteroffer revoked my offer. capacity to contract. We talked about minors. We also talked about legally being adjudicated incompetent, but let's begin with minors. A minor is said to lack capacity to contract, and what this means is that any contract a minor makes during their minority is revocable at the election of the minor. There's a rule that's applied in a majority of states, including Virginia, and this is a common law rule, and that is that minors must pay for the reasonable value of necessaries. Necessaries are food, clothing, and shelter. By statute, in a majority of jurisdictions, minors are also liable for contracts made while running a business, for education loans, and for contracts for medical care. So what if a minor misrepresents his age? Then what? Well, if a minor misrepresents his age, we're still going to allow that minor to avoid the contract. The difference now is that because the minor has committed fraud, the seller may also revoke the sale. Mental capacity. The point that I wanted you to take away from mental capacity is that once you've been legally adjudicated as incompetent, you no longer have capacity to contract. And any contracts you made after a court has determined that you've been legally adjudicated incompetent, they are void. Not voidable, but void. Intoxication, we found in the Lucy versus Zamer case that intoxication essentially has no effect on the validity of a contract unless you are so intoxicated you have no idea what you're doing. And then I briefly mentioned corporations, and we will get back to this when we get to forms of business organizations, but when a contract is beyond the corporate purpose, it's said to be ultra-virus or unenforceable. Other defenses to the validity of a contract I need to mention include mistakes. A unilateral mistake, that is one party to the contract makes a mistake, generally does not affect the validity of a contract unless it is so big the other party either knew or should have known that a mistake was being made. Mutual mistakes, you need to make the distinction as to whether the mutual mistake is one of law or one of fact. A mutual mistake of fact would void a contract. Mutual mistake of fact was one that we talked about in the Florida versus Treasure Salvers case. This was the Mel Fisher case. And so go back and review that one. Other defenses to the validity of a contract. Duress. Duress is a wrongful threat, and it creates a situation where a contract is voidable. If there is extreme duress, and you know this when you see it, extreme duress, someone holds a gun to your head and says, sign this contract or I'll shoot, creates a void agreement. Fraud in the inducement is the intentional misrepresentation of a material fact that's relied upon to the detriment of the relying party. This is a defense to the validity of a contract as well. A contract would be voidable and money damages could be sought. There must be scienter or intent to deceive. You need to remember that term. And the misrepresentation must be a statement of fact. So if I tell you, this smart car is a real beauty, you should buy it. And you buy it and you hate the car, and it turns out to be a real lemon, have I made an intentional misstatement of a material fact? And the answer is no, this is just an opinion, and this would not constitute fraud. Fraud in the execution creates a void agreement, and it occurs in the form of the agreement itself. So let's say you're a celebrity, and I come up to you, and I've hidden a promissory note by a blank sheet of paper, and I say, please sign this paper. I would like to have your autograph. And you sign it, and it turns out to be a promissory note. That would be fraud in the execution, and that promissory note would be void without legal effect. Undue influence, the last defense to a validity of a contract, only occurs if you have a fiduciary relationship. And you may unduly influence someone. If you're in that fiduciary relationship, it could be doctor-patient, attorney-client, mother-daughter, father-son. You get the idea. And this is a defense to the validity of an agreement. Consideration. Offer acceptance consideration, the third major part of a valid contract. Consideration is the price paid for a promise. You found out that consideration could be money, it could be services, it could be goods, and in fact, consideration can be giving up a right to do something, and this is known as forbearance. It's the element that distinguishes an offer to make a gift, which is not binding, from a binding contract. Remember that forbearance, or giving up a right to do something, could be consideration, and the case that we went over in class involved William Story Sr. giving $5,000 to William Story II in exchange for a promise to forbear or to give up gambling, smoking, drinking, cursing, and fighting until he was 21 years old. Young William did this, and at the end said, "Give me my money," and does the court have to pay young William the money? Is there consideration? Is giving up a right to do these things, is that adequate consideration? And the answer is yes. And then some exceptions to the requirement of consideration. Charitable pledges are enforced not because you have offer acceptance consideration, because there is no consideration, for public policy reasons. The UCC, next week we will talk about 2 exceptions to the rule of consideration: merchant's firm offers and a good faith agreement to modify a contract. Sealed instruments at common law. This is a form of a formal contract, and this is enforced not because you have consideration, but because of the formality with which it was executed is sufficient to show the world that you really intended to enter into a contract. So a sealed instrument at common law, and we still recognize those in Virginia. Those would be a contract where your signature is notarized. And then, of course, promissory estoppel is one way that the courts get around the requirement of consideration. So this doctrine would apply if the person making the promise has reason to foresee detrimental reliance. The promisee did, in fact, rely on the promise and would sustain a substantial loss if the promise were not performed. And so many courts do enforce promises that are not supported by consideration by applying this doctrine of promissory estoppel. Auctions, you need to know that an auction may be with reserve or without reserve. If an auction is with reserve, the item that's being sold does not have to be sold to the highest bidder. Without reserve, the items do have to be sold to the highest bidder. The statute of frauds, or form of a contract. Certain contracts, not all, but certain contracts must be in writing to be enforceable. And those agreements must be signed by the party being sued. Another way to put this is signed by the party against whom enforcement is sought. The writing is going to have to identify the contracting parties and specify all the essential terms. The effect of noncompliance with the statute of frauds is that an oral promise is not enforceable. So here are some of the contracts that must be in writing. A contract that cannot be fully performed within a year must be in writing. Agreements to sell real estate, they should be in writing. The promise to pay the debt of another person should be in writing. Likewise, the contract of an executor of an estate to pay the debt of a decedent needs to be in writing as well. And we will learn that contracts for the sale of goods costing $500 or more must be in writing to be enforceable. There's an exception to the rule, and that's the specially manufactured goods exception. I have asked you to read the Flowers Baking versus RP Packaging Company, and we will talk about this next week. The parole evidence rule. And so we have this rule because we want stability in commercial transactions. So when a contract is in writing and it otherwise looks complete, the general rule is that parole evidence or spoken words will not be allowed to contradict or modify the terms of the written agreement. If, however, a contract is ambiguous or unclear, then a court may allow parole evidence. And so the example we went over in class was, I have 3 smart cars and I agree in writing to sell you my smart car for $2,500. The court would allow in parole evidence to prove which car is my car. The effect of illegality. Illegal agreements will not be enforced, and in fact, the courts do not come to the aid of either party. pursuant to an illegal contract. In fact, they just leave the parties right where they are. We will find out when we get to contracts for the sale of goods that sometimes the courts look at the element of good faith and fairness. And if there is grossly disproportionate bargaining power, the courts may come to the aid of the weaker party. Don't ever count on the courts coming to your aid, however. And that's it for the review of contracts in a nutshell. Hope you have a good weekend. And next week we will cover sale of goods under Article 2 of the Uniform Commercial Code. Thanks.